the perfect transition for me to do a very quick analysis of about a half a dozen Supreme Court decisions that were decided in this last term, especially some real serious ones in the last 2 or 3 days of the term. So the Supreme Court held that a race-based or race consciousness affirmative program addressing the University of North Carolina and Harvard. Now the difference there, the University of North Carolina is a state school, therefore the Constitution applies. Harvard is a private institution, and the 14th Amendment, we generally think for private places, the 14th Amendment doesn't apply. But Article 6, or Title 6 of the U.S. laws say that if any institution is accepting federal funds, they can't discriminate based on race. And the Supreme Court has already held that if someone is violating Title 6, they're also violating the 14th Amendment. So therefore they lumped them together and said that what North Carolina was doing and what Harvard was doing was unconstitutional, because what they were doing is they were using race as a factor. And the Supreme Court Chief Justice Roberts has been saying for a long time, very naively in my opinion, that if you want to end race discrimination, then you've got to end any race discrimination, meaning that it applies to white people just as it applies to blacks, brown, and Native Americans. I really urge people, if you get a chance, there were 6 different decisions in this case. In total, it's 229 pages, which is a lot to read. But if you have an hour, or maybe even 45 minutes, take a little of what Chief Justice Roberts writes. For example, as is pointed out by Justice Jackson in her dissent, they're saying you can't use race consciousness in allowing people to go to school. But in footnote 4 of the opinion for the Supreme Court by the Chief Justice, they raised the part about that the U.S. government, the Biden administration, raised the issue about, in the amicus brief, about affirmative action in the military. And so Roberts said, we recognize that that's not in this decision, and therefore we're not addressing that decision. And Jackson really, in my mind, said, I got it. So what the majority is saying, that we allow black people to be in the bunker, but we're not going to allow them to be in the boardroom. So, the one decision that I learned so much from is Justice Jackson's decision dissenting on this case. The first 15 of her 29 pages is a history, starting off with the 3/5, all the way through about how we systemically, institutionally, have discriminated against black people in America. And she talks about wealth gaps. And you want to know why we have wealth gaps in America today? Because if you look at the history from the beginning, it's very clear. And she has some wonderful lines in there about one part. She says, in the philosophy of let them eat cake, she talks about how naive the Supreme Court is now adopting this position that we should be colorblind, when in fact we've never been colorblind. And we're not colorblind today either. So by declaring that we're going to be equal and colorblind by legal fiat is naive to think that that's what's going to happen. So her decision, just one other point on that, just think if she wasn't appointed, and it's clear, Biden said he wanted a black woman. So that's more than a factor, but the other factors is she's brilliant, she writes well, she is experienced, and will be an excellent justice. But just think for a moment, if she wasn't on the court, then the discussion historically for children, grandchildren, their kids, would only have a perspective this wide as opposed to this wide with her being there. So that's the best example of why race as a factor, not as the only factor, but as a factor, I believe is not only constitutional, but it's the only way we're ever going to try to get to the point that we have equality along race. So this decision also is an example which I'll make the point that they're undoing legal precedent. Last year, with regard to Roe, they overturned Roe versus Wade, which was 50 years on the books. This year, what they did, women's rights, this year, what they did is they undid legal precedent of 45 years. From the Bakke case in 1978, which was at the University of California, at Davis, to 25 years later, in 2003, the Grutter case versus Bollinger, which was at the University of Michigan Law School. And in that case, Sandra O'Connor, whimsically in my opinion, said it's 25 years since the Bakke case, which allowed you to take race in for diversity purposes. So we hope and expect within 25 years from now, we'll end affirmative action. So it's actually 20 years since then, but technically under that, we had another 5 years of affirmative action. But that was ridiculous in and of itself because you can't arbitrarily set things like that. When do you get rid of affirmative action? When we get to the point where we're completed in making sure we have real equality for people based on race.
Right.
So her decision is so good, and I'm so glad that she's on the court because history will read that decision and understand it. Similarly, the second case, the Colorado case, which deals with a First Amendment right that the court, Gorsuch, wrote for the court, saying that a web designer who objects to same-sex marriages does not have to comply with the Colorado law that prohibits discrimination based on sexual orientation. Now, in this case, if you have some additional time, read Sotomayor's decision and dissent. She goes through the first half. I think Jackson and Sotomayor are two sisters in sync because Sotomayor's dissent does the same thing with regard to history against gay folks in America and traces the history and gives examples, really moving examples of the lack of dignity that people face when they're walking in an area and the kind of stigmatization and the discrimination that exists towards people from the LGBTQ community. The fact that these two women are on the court and are able to go through the history and educate the public with regard to why we are where we are, I think is wonderful and important if we're trying to persuade people. And what I've said before, for many years, when the legislative and executive branches of government don't do the right thing on social justice and freedom and equality, we then go to the courts. Well, now it's kind of reversed. We've got a Supreme Court that the majority is clearly an ideologically conservative court. And they're looking for certain cases, even cases like the one in Colorado, which is a made-up case. Why is it a made-up case? No one actually complained. Even worse, there was no website. It was all in her head. And some people, theoretically, and the traditional stuff that we learn in law school is you need a case or controversy before the court can take a case. Otherwise, it's what's called an advisory opinion. Furthermore, we find out unbelievable criticism from A to Z on this one. Criticism to the people in Colorado the government and the lawyers, criticism to the media, criticism to the courts in the federal court and the Supreme Court, because part of the argument was a guy named Stewart who wanted her to make the website for his gay marriage. When we find out 6 years later or 8 years later that they find the guy Stewart in California, and he says, yeah, but I'm not gay. I'm married to my wife for 10 years, and yes, that's my name, that's my phone number, but I didn't make the complaint. So even the argument that someone was making the complaint turns out it's bogus. And yet, here, all the courts, including the Supreme Court, and furthermore, the people in Colorado who were in the Attorney General's office, they made a stipulation with regard to this case, agreeing to 10 things, including that the web designer, that what she was going to do was her expressive activity protected by the First Amendment. So if I go, I'm on, and I said, I want you to make a website for me, and here's what I want on it, ABC. Is it his speech or is it my speech?
It's your
I think
speech.
it's my speech because I'm paying him to express my view. They didn't see that. And finally, there's one other element in this case where even if it was speech, it's incidental to the issue at stake. The legitimate government interest is specifically to make sure in public accommodations that we don't allow in a commercial setting the business owner to discriminate based on protected classes. And so they've opened the door now to do that. So I'm a lawyer. I'm a public accommodation. It's open for business. If someone comes and tells me they want me to bring a lawsuit and I turn them down, can they say that therefore I'm denying them their First Amendment right of expression? And finally, in this case, on her right to expression, she can still write her gibberish. She can still write whatever she wants. She can speak out against same-sex marriage. So her First Amendment right hasn't been compromised or compelled. Also, very important, the court found that President Biden's plan to undo student loans for tens of millions of people, worth over $400 billion over a long period of time. It's basically you can get 20,000 reduced over a period of time, or if you're making less than 125,000, 10,000. The key, in my opinion, on this stuff is to either reduce or eliminate the interest on the loans, because the loans are one thing, but if you don't pay it over a period of time, the interest can be even more. So he specifically announced that he was going to come up with a new plan, and we'll have to wait and see. Ann's now here. All right, we actually have this official. All right.
She could do it.
Hopefully it's dry.
Sorry, I'm late.
No, it's all there was also a very important case where, again in North Carolina, they came up because of a provision in the Constitution that said that federal elections are the time, place, and manner are determined by the state legislature. So therefore, when they did reapportionment for the congressional seats, the state court at that point, which was Democrat appointed, ruled it illegal. So the people of North Carolina were saying the courts should not get involved in these issues. Now, what's happened in the election in November, the Republicans took over the court, and all of a sudden this wasn't such an important issue, but it's the independent state legislative theory that the state legislatures can determine on federal elections and not the courts. That would be terrible, because a lot of states have Republican legislatures controlled at this point. So that was defeated 6-3. On the voting rights issue, the court surprised everyone with a 5-4 decision that the court ruled that Alabama diluted the black community's voting power by approving only one single congressional district where the blacks were a majority. So they said that Alabama couldn't do that. There's a case in Louisiana which was the same thing, the Supreme Court did the right thing and sent that back. And that's important because see how close the House of Representatives are now with regard, we talk about 3 or 4 difference. And if you can get over the House being Democrat with a state Senate, with a Democrat in the presidency, you could probably create more kinds of legislation than we have at this point. For Native Americans, the court ruled that in 1976, the Indian Child Welfare Act was legal when it seeks to keep Native American children within their tribe. And finally, the court held on religious grounds, this was 9-0, that employers, in this case it was UPS, that's just the trees. The trees are speaking. So I'm going to end with this one. They held that the postal worker did not want to work on a Sunday because it was a Sabbath, and the court said that the employers have to create reasonable accommodations for someone's religion, and that was 9-0. So again, in summary, the court has spoken this year, the previous couple of years, and they have a solid conservative ideological majority, 6 people, 3 liberals. Some people say it's 3 Alito, Thomas, and Gorsuch on the far right, Roberts, Kavanaugh, and Arnett Barrett in the middle, and then Sotomayor, Kagan, and Jackson. I don't buy the 3-3-3. I see it as 6-3. And on various issues, they'll give us a crumb, but they then, on the most important ones, they speak up. So what do? They're protecting the issues of religious freedom. They're protecting gun owners, and we basically have a situation where a lot of the people on this court, except for Thomas, are relatively young. So they're going to be there for a period of time. They'll probably be there as long as I'm going to be around, and they'll probably outlast me here. So in the context of that, what can we do? Well, I look at most of you, you know how to do it better than I do.
Or acid on the brake line.
Excuse me?
Or acid on their brakes.
I'm a lawyer, I can't approve of that. And as a human being, I would defend it on that one. We have to get a lawyer to do that. But we have to
retire when you're senile.
Well, I think that we have to continue to do what we're doing. We will not be silent. Shiraz is aware of that all the time. We have to speak up. We have to do our things. We have to do stuff like this. And as what happened this morning, it was pouring. Look at it now, the sun's out. So my suggestion is when it rains, wear our rain equipment. When it's sunny, get out there and try. I really think we can change people's minds. We just have to figure out how to listen and how to persuade people that the direction this country's going in is good. So anyway, that's it. We're going to have a couple more songs.
So before we sing, I just want to say something. That the people that are walking back and forth, the main thing that they have responded to in terms of stopping and listening and not being afraid is that I came up with, I said, we're here to honor these women. Everyone I said that to stopped and listened to what else I wanted to say. So I think the way we package things and the way we frame it brings out the best in people. That's it.
This is a very good site, and because there's so many, as we found out last year, there's so many people who walked by and actually joined in the singing. With this is our package. You did it very nicely. I did right. All right, let's have some song.